Sponsoring his CLE program today. I put some brochures on the table so you can look at the programs that we offer our Utah students each year. More than 30,000 Utah students participate in one or more of our programs every year, and we have over 700 attorneys and community members who volunteer each year. So we couldn't do it without them, and please, I encourage you to please look at the brochures because we'd love to have you join us as we bring these wonderful programs to our Utah students. Randy?
It's kind of a tepid introduction to your loving husband. It's a great turnout. I'd like to think it's because you're all here because of a wonderful presenter, but I realize it's the topic and the fact that you're probably all one hour short of your ethics. We've got a lot of material to cover today, so I'm going to talk very quickly and go through material quickly. But you can get a PDF of my PowerPoint slides. Will be available. I just need to let Connie Howard from the FAR CLE send her an email or talk to her afterwards, and she will send you a PDF of the slides. So watch the screen, listen to me. Don't worry about taking notes. All right. Well, when I talk about social media around the state, I always like to kind of get a little feel for how sophisticated my audience is. So, just by a show of hands, how many of you have a Facebook page? Quite a few. You're one of 850 million people in the world that do. How many of you have a LinkedIn account? Again, quite a few of you, which is not surprising for lawyers. How many of you have a Twitter account? Okay, not quite as many. I'm media law guy, so send me, start following me. I'll respond and follow you back if you're looking to expand your Twitter audience. How many of you write a blog? Okay, here's the ultimate test. How many of you have an avatar on Second Life or Farmville? Okay, we'll ask you what your avatar is. Probably a wrestler or something. But, all right, well, today we're going to talk about the ethical risks of lawyers playing in the social media sandbox. We're going to answer 3 questions today. Should I even care about social media in terms of my law practice? Second question is, as a lawyer, do I have an affirmative ethical duty to address social media in my practice? And the final question we'll answer today is, are there any social media ethical traps that are lurking out there to catch the unwary lawyer? All right, so for the first question, as a lawyer, should I even care about social media? Well, I'm going to show you 4 images, and then I'll explain those images that will answer that question. We apparently have some people conferencing in. That's what you're hearing. All right, so let's look at those 4 images. What does this have to do with social media? Well, this is a photograph of a purse. It happened to be Paris Hilton's purse, and she was in a routine traffic stop, was stopped, and the police found some cocaine in a purse that was in her car, and she was arrested and charged. She said, well, it's not my purse. That was one of my friend's purses who was in the car. Well, that was her position until the prosecutors found on her social media account, her Twitter account, this photograph. It's too far away to read it, but basically the caption at the bottom of the photograph. This is her photograph she took, posted on her Twitter account, and the caption reads, "Love my new Chanel purse I got today," which just happened to be the same day that she was arrested. All right. This is a referee, obviously, throwing a flag, and this sort of represents the fact that bar disciplinary bodies are more and more becoming asked to give opinions and rule on lawyers' use of social media, and this is something we'll be talking about where it's a minefield out there for you in terms of ethical violations. This is the caption of a spoliation order, something that hopefully no one in this room will ever have to see. It's a sanctioned order against a lawyer and his client. We'll talk about it in a little moment. It involved social media. And this final graphic is just sort of a depiction of the fact that new technology is basically causing so many stresses in the legal profession that the practice as we know it is being torn asunder, if you will, and will be reconstituted in a variety of different ways, which we've not yet been able to imagine. So those are 4 different reasons why you should care about social media. Some other reasons are the fact that social media is so prevalent in our society today. I'm going to go through, just give you some quick statistics on the top 3 social media networks. This is Facebook. This is my Facebook page here. But there are 850 million people in the world that have a Facebook account. That is 11% of the world's population. There are over 1 billion posts made on Facebook every single day. And there are 4.6 billion photos. Facebook is now the largest photo repository anywhere in the world. It's been a boon for law enforcement, as you might imagine. Chances are your clients are on Facebook, so that might be a reason in and of itself that you ought to be familiar with how it works. Twitter. This is a screenshot of my Twitter page taken a few days ago. Again, I'm a media law guy. If those of you who are on Twitter, follow me and I will reciprocate. Twitter has 465 million users. It's one of the fastest growing social networking sites. It has changed from just being silly, what am I eating right now, or where am I going to now? It's become sort of the early morning fast breaking news. Most major news breaks on Twitter before it ever gets reported in the mainstream media. It is one of the fastest growing social networks. There are 175 million tweets are made every day, and there are 11 accounts, new accounts opened every second. This is a screenshot of my LinkedIn site. 140 million users. 45% of the LinkedIn users have incomes greater than $100,000. Lawyers are the 3rd largest segment of LinkedIn network holders. Educators and communications and IT are the 1st and 2nd. All right, well, let's take a look at how social media's reach has really dramatically expanded in the last few years. I've got just a brief little video to show you, and I will tell you that this video, although it's only about 4 months old, is already out of date. Okay, well that gives you just a quick idea of how rapidly social media is growing. I mean, to put the Facebook number in perspective, if Facebook were a country, it'd be the world's third largest country, China, India, and Facebook. Well, since 2010, there have been 688 published decisions that involve mostly evidentiary issues relating to social media. And you can imagine how many hundreds of others unpublished decisions. The top 5 matter types of these cases are criminal, employment, insurance claims, personal injury, family law, and trademark and infringement. So, the answer to the first question, should I care about social media, hopefully you now realize that the answer to that is a big giant yes. Clients are using social media. All your competitors are using social media to market themselves. Most of the larger firms now have blogs, they have Facebook pages, they have Twitter accounts. Lawyers are using all the social media to market themselves. And social media has become an essential tool in practicing law. You can now go to seminars where you learn how to use your iPad in litigation. And iPad is taking over all of the trial presentation, both hardware and software. So the answer to question 1 is yes. You should care about social media, because if you don't, your competitors are. All right, question 2, do I have an affirmative ethical duty to address social media? Well, in terms of the case law and ethics opinions, this is an unanswered question in Utah, but we can look to cases and opinions in other jurisdictions to give us a pretty good idea of what the answer to this question is going to be in Utah. Of course, the starting point to answering this question is the rules of professional conduct, and in particular, Rule 1.1. Rule 1.1 says, I haven't quoted the entire rule, but a lawyer shall provide competent representation to a client. And comment 6 says a lawyer should keep abreast of changes in the law and in its practice. Does this include keeping up to speed on social media? Well, here are just a few other states in how they've answered that question. This is a decision from the Maryland Court of Special Appeals. This was a murder case. There was some evidence from the defendant's girlfriend's MySpace page, and it was admitted into evidence. The conviction was a key piece of evidence. The conviction ended up getting reversed because the judge did not follow all the proper authentication protocols for getting social media evidence introduced, and so the conviction was reversed. But the court made this statement: it should now be a matter of professional competence for attorneys to take the time to investigate social networking sites. The Missouri Supreme Court made this statement in a Med-Mal case: attorneys have greater responsibilities in light of advances in technology allowing greater access to information. This was a Med-Mal case. The jury was asked in voir dire about, have any of you been a plaintiff or a defendant in a lawsuit? Juror X said, no, I have not. After the jury was impaneled, and after there was a no cause, the plaintiff's counsel did some research and found out, in fact, by looking at their social media posts, that Juror X, in fact, had been on involved in 3 different litigations. In fact, was a defendant. And so the counsel made a motion for a new trial, and that was granted. The defendant subsequently appealed. The appellate court upheld that case and made this observation, that attorneys have an obligation to do research about jurors, admonished the council a little bit about doing it after the jury had already been impaneled, and said because of that, you can't show that there was any prejudice or that you would have used one of your peremptory challenges to stricken a juror beforehand. But in the future, henceforth, said the court, in Missouri, you need to do your research about jurors beforehand, and if you do not, you will waive your right to make any challenge based on a juror not disclosing something that should have otherwise would have been disclosed on social media. The New Jersey Appellate Court made this statement about whether attorneys have an affirmative obligation to educate themselves about social media. The court granted a new trial to the plaintiff where the trial judge had barred the lawyer from doing online research during jury selection. It is not uncommon now for you to bring your laptop, your iPad, or a tablet to court with you. Most courts now have wireless access where you can have your own wireless card, and you can do jury research right on while you're examining the juror. In fact, there's an app for it. There's an app for everything called iJuror. And iJuror, you can load that on your laptop, and it'll have little icons for each juror, number 1 through whatever, and you can do real-time research on them on their social networking sites. You can record all of the questions that their responses that they have to the voir dire questions, make little notes, and so it's a little software tool to help you in your jury selection. So the judge, the plaintiff's lawyer was using his laptop to do real-time jury research while the jury was being selected. The defense counsel didn't like that, didn't have a laptop and objected, and the judge ordered the plaintiff to close his laptop and prohibited him from doing that, saying, well, if you'd given advance notice, so maybe opposing counsel could have made their arrangements to do their jury research differently, but because you didn't, I'm going to prohibit you from doing that. On appeal, that order was reversed, and the judge made some comments saying it's almost malpractice if you don't utilize these new social media tools. So hopefully the answer to that question, again, is a big unqualified yes. All right, let's move on to the third question, which is really the one that you should pay most attention to, which is, are there any social media ethical traps for you as a lawyer who may not be sophisticated in social media or think it's for someone else but not for you? Well, obviously the answer to this question, I'll just tell you right up front, is yes. And there are too many potential traps out there to discuss that in the 35 minutes we have left, but I'm just going to flag 6 potential areas that you at least ought to be thinking about. Litigation holds. Now, we all know about litigation holds with the discoverability of ESI, but ESI includes social media posts. We'll talk about this in a minute. Spoliation concerns. Social media just exponentially increases the possibility that someone's going to be making a spoliation allegation against you or your client. Another area of concern is social media contact with parties, with witnesses, and with jurors. Another area that's just emerging is what are the ethical rules and ethical concerns about contact with judges. You as a lawyer contacting a judge. You all know about the traditional prohibition on ex parte contact. Well, how does that translate and how is that applicable in social media? We'll talk about that briefly. Advertising is another area where there are great potential ethical risks if you use social media platforms in which to advertise. And just trust me, within a year, you'll all be doing some form of marketing, if not traditional advertising, through social media networks. And then we'll just highlight some other areas that you should be concerned with. All right, so let's look at litigation holds. Again, I've just pulled some quotes from some recent decisions that underscore the importance of litigation holds. This was a decision in January of 2010, and you can read it. It just basically says, hey, if you do not issue a litigation hold and a written litigation hold, that constitutes gross negligence, because it's likely to result in the destruction of relevant information. And this is particularly applicable to social media. We all know about emails, so we all tell our clients, now, okay, we've been sued, or there's a likelihood of suit, or we got this litigation hold letter. Make sure you turn off all your automatic archiving and deletion of your emails. Everyone pretty much knows to do that. What some people don't think about is, oh, and you also need to make sure that you tell all of your employees that they've got to preserve all of their tweets and posts on their mobile devices. Mobile is the big thing. More and more people are accessing the web through mobile. So it's no longer just emails, it's no longer just preserving all the searches on your computer, it's preserving things on your mobile devices. Tweets, posts on bulletin boards, comments made, everything that just opened up a huge pool of potential evidence that you now have to be concerned about. Is that within the scope of this litigation hold? And the converse of that is when you are sending out that litigation hold letter, you make specific reference to social media and social networks. So this case, which resulted in a pretty good sized sanction, I thought this quote by the court, the court was particularly telling. The court found that the plaintiff was grossly negligent in, this is another case, Crown Castle, and there they found that they were grossly negligent not only in failing to issue a written report like in that pension case, but the court extended the admonition even further. They said not only must you issue a written litigation hold that is sufficiently broad enough to include social media, but you must monitor, you as the counsel must monitor the collection of the responsive documents. You can't just turn this over to your client's IT person. And you, as a lawyer, have an affirmative obligation to ensure that relevant documents were not destroyed. So you can no longer just say, meet your ethical obligation by sending a litigation hold letter. You've got some duty to ensure monitor compliance, at least in the state of New York. That's this Crown Castle case. The defective products case primarily involved emails, but there are some references in the decision to social media. And then the final case I'd like to bring your attention is the Jones v. Bremen High School District case in Illinois. This was a discrimination suit, and again, it primarily related to email, but this just again underscoring the trend that seems to be developing in the case law that you cannot just issue the litigation hold. You've got an obligation to make sure that your client is actually following the litigation hold, and you cannot essentially delegate to your client, even to a general counsel of your client, the decision-making authority on what is within the scope of the discovery request or the litigation hold request or whatever. All right, well now let's just look at a case that did involve social media. And this is a case that hopefully none of us ever have to experience ourselves. It's Lester v. Allied Concrete Company, a decision in Virginia State Court. It's presently on appeal. We'll see whether the judge's quite harsh sanction that was issued in this case holds up. But basically, what happened in this case is the plaintiff, on the instruction of his lawyer, deactivated his Facebook page. This was a wrongful death case. The husband was the plaintiff, suing for the death of his wife, and he was the aggrieved widower, or widow. Jeez, I always get those two mixed up. Anyway, he was the plaintiff in this wrongful death suit, claiming that he was suffering from severe depression as a result of his dearly beloved wife having been killed by Allied Concrete Company. His lawyer, savvy enough to look at this guy's Facebook page and found a bunch of photos that he didn't think would probably, if they were shown to a jury, would be well received. One like within a week after his wife's death, where he's so depressed, he's got it shown that he posted a picture of him at a party. He's on, has a beer in his hand with little t-shirts that says, "I love hot moms." So he said, clean up your Facebook page. Why don't you just clean up your Facebook page? Well, he did. He deleted about 15 incriminating photos, and then he finally just deactivated his account. To make things worse, when he was deposed, he was asked, "Do you have a Facebook page?" And he said no. At the time, that was correct. He didn't, because he had deleted it on advice of his lawyer. Well, they found out about that. They asked for all the communications between the lawyer and the client. Those were resisted on the ground of attorney-client communications. The court determined that privilege would not be recognized, and as a result, this lawyer was sanctioned $522,000. His client was sanctioned for $180,000. Nothing any of us ever hoped to see. That's now on appeal. He's appealed the harshness of the sanction. Allied Concrete Company has appealed because they had asked for $900,000 of sanctions, and the court didn't award it all. So, very, very problematic issue of spoliation, things that you would not ordinarily think. I can certainly see myself saying, "Oh man, that's probably not a good, be careful what you post on Facebook, that's probably okay, but take something down on Facebook," you can kind of see maybe you might say that. Well, at least in Virginia, you better not. All right, so what about contacting parties and witnesses through social media? Well, first place you should look, of course, are the rules of professional conduct. So, Rule 4.2 is the rule that governs communication with represented persons, and of course, we all know that's prohibited. Rule 4.3. I hate to hang this up because I think we got 3 people. Well, they'll probably get repeated every time. All right, Rule 4.3 deals with communicating with unrepresented parties, when a lawyer can and cannot do it. And then, of course, Rule 8.4 talks about lawyers engaging in any dishonesty, fraud, or deceit with respect to their representation. All 3 of these rules have potential implications for social media. We just don't have time to kind of go through all of them today in detail. We're beginning to see states, bar ethics opinion committees issue opinions on this. Here are 3 that were part of a handout, so you can read them yourselves. Basically, there's some exceptions, but generally, you can review public information on a witness or a party's social media site. What you cannot do, generally with some exceptions, is send a friend request to them. Or have your paralegal send a friend request to them. Or have your investigator that you hire send a friend request to them. If the purpose for you sending a friend request is because you kind of want to know a little bit of information about this prospective witness or the party, these three bar ethics opinions have said that's a no-no and violates the rules. There are a couple other opinions that have dealt with what contact may you have with jurors. Now you think, well, why? That's pretty obvious. You just don't have contact with jurors, right? Well, sure, but you may inadvertently have contact with jurors through social media. Passive monitoring is okay, but you may not act in any way by which the juror becomes aware that you are monitoring them. Well, okay, you say, well, what does that mean? Well, for those of you who have a Twitter account, you know what I mean, right? You follow somebody, that person who has a Twitter account, they get a little message from Twitter that says, Randy Dreyer is now following you. There have been several, these two opinions have said that's a no-no. Because the juror now knows that lawyer representing the plaintiff is following them. And that may make them uncomfortable, may imply something inappropriate. So you cannot follow a juror, even though they don't have to, it's not like a friend request where they have to accept. Just the mere fact that you are following them violates that admonition against contacting jurors, at least in New York and Philadelphia, the only two states that have issued opinions on that subject. Now, there is some available, mothers, with necessities, the mother of invention. There is a commercial product that you can buy that will allow you to look at the last, I think, 3,200 tweets of a person without triggering that you are following that person. So you could buy that software and use it for your jurors if your case was significant enough to justify that. All right, we've talked about contact with witnesses and parties and jurors. Now let's talk about contact with judges. Well, I know many of you are thinking right now, well, why is that even an issue? Judges don't have Facebook accounts, do they? Well, I'm sure you'd be surprised to know that there are two members of our U.S. Supreme Court that have Facebook pages. There's one member of our Court of Appeals, and there are dozens of trial court judges that have Facebook pages. So, what is the answer? Can you have contact with judges in a social networking situation, whether it's Facebook friends or LinkedIn contacts or Twitter followers or what have you? Well, it depends on the jurisdiction that you're in. Florida and Oklahoma say no. Judges and lawyers cannot be Facebook friends. It is a violation of the Code of Judicial Conduct, and it is a violation of the professional rules of conduct for lawyers. Lawyers and judges cannot be Facebook friends. That's not the same in the case in Ohio, New York, Kentucky, and a couple others where it is okay for lawyers and judges to be Facebook friends, provided there's some cautions and some limitations. Well, what's the answer to that question in Utah? It's an open question. We will soon know the answer to at least some of those questions because there are 3 pending requests for opinions from the Judicial Ethics Advisory Committee addressing this. These literally were made this week. One was made Friday, the others were made this week. I know about them because these are 3 judges who I served on a bar or a judicial council committee dealing with social media, and I helped them craft the opinions or the opinion request. So Judge Michelle Christiansen has submitted an opinion request. She is Facebook friends with lots of people, including lawyers, myself included. She was before she went on the bench, she was a partner. She was at Parsons Bailey, my firm. Third District Judge Andrew Stone and Juvenile Court Judge Nolan. Those three have asked these pending requests. And let me just read you some of the requests, some of the questions they're going to be asking for opinions on. May I be friends with or accept friend requests from lawyers who do or may in the future appear before me? Does the fact that I'm Facebook friends with a lawyer require my recusal from a case assigned to me in which that lawyer has appeared? May I identify myself as a judge on my Facebook profile or my LinkedIn profile, either by specific reference to my profession or by appearing in my public photo in my robes? I talk to people about that, and they go, of course not. There's a judge who has his Facebook profile picture is in his robes. And you think, oh, that's probably not a good thing. But you look at who his friends are. They're all friends in a foreign country. He happened to have served an LDS mission. That's the way he communicates with them. And so for them, to have him be depicted as to what his profession is as a judge is, that probably puts it in a different light than you might initially think. May I like, all you Facebook folks, like is replaced being a fan of something, but you like something. May I like events, companies, institutions, activities that may advertise or post on Facebook? If so, must I recuse myself if that company or institution has a matter before me? Not only may I be friends with lawyers, may I be friends with individuals who are candidates for public political office. Of course, there are judicial canons that prohibit judges from engaging in political activity. Does that violate the rule if you are friends with an elected official or a candidate for political office? So we'll know the answer, at least to those questions, hopefully sometime in the not too distant future. All right, let's talk about very briefly, so I want to leave some time for questions about advertising issues. As I said earlier, in one form or another, every lawyer is going to end up doing some form of advertising or marketing in a broad sense through social media. Of course, the hot topic right now are these daily deals through Groupon, and lawyers are beginning to see that as a way to attract clients. And of course, this raises issues about, is there prohibited fee sharing? Because of course, the social network site takes a percentage of, there's a fee for you being listed. Part of the daily deal, come in today and you'll get your will for $100 instead of the normal $300 charge or whatever. What about people who sign up for these daily deals? They buy the coupon and then they never use it. They never use it. Well, does that mean there's an excessive fee? You never earned your fee. You never provided the service. You never drafted the will. You have to refund that. So that's an issue that's currently being worked through. And then what about all of these ads? These ads are the daily deal or Groupon or whatever. They do the advertising for this, and you really don't have a lot of control on it. And there's been one opinion on this, well, there have been several opinions, but the one that's the most thorough in terms of its analysis is out of New Jersey. Again, this is way too much information on a PowerPoint slide, but basically you could see it when you order the PDF. But there were a group of New Jersey lawyers who got together and there was a bankruptcy referral site. And each of these 15 lawyers represented a particular geographical area in New Jersey. So here was this, there were and users who wanted to get this group deal filled out a form, and then they got a free evaluation from a local attorney. And the lawyers paid a fee to be part of this, this referral service. And there was a challenge about whether that violated the prohibition against fee sharing, whether or not the advertising was misleading. And these lawyers ended up being disciplined, not because it was a prohibited fee sharing. That was found to be okay, because really the cost was really for their advertising, if you will, and it really was not a fee. So there was no prohibited fee splitting with this referral service. But the ads were misleading because to the user, it looked like they would sign up for this service, and then they would be contacted by a local lawyer in their area, and then they could choose which lawyer they wanted to hire. But in fact, there was only one in each geographic area. So this is sort of the leading opinion on that. So what's the bottom line on all of these advertising issues? Discounted fees are okay, you can participate, but there's no discount on ethical and professional obligations. Okay, in the remaining time, I'm just going to go through some other potential ethical issues just to get them on your radar screen so that you can be aware of them. Unauthorized practice of law. More and more people are hooking up with lawyers via the internet. I'm now teaching full-time at the University of Utah, still of counsel with Parsons, but before I left, I'd say over 50% of my new clients they found me through the internet. It used to be more than half of my referrals came from other lawyers who had a specific media law or First Amendment issue that they didn't feel capable to handle. More and more lawyers are getting referrals and getting contacts by the internet. A client calls me now, they know a lot more about me than I know about them. They've looked at my profile, they've Googled me, they've done all sorts of research, so they kind of know a lot more about me. Well, if you participate in a chat room, there are these all sorts of ways in which you can essentially comment, or maybe it's close to giving legal advice. Well, you might, if that person who you're communicating with through a social media site or even just through old-fashioned email, if they're in another jurisdiction and you're not licensed there, that can raise all sorts of problems about you being engaged in unauthorized practice of law. Inadvertent disclosure of confidential material. Social media is just a whole other set of new communications channels in which you can inadvertently disclose confidential information. The classic case was there was a confidential merger, and the lawyers traveled in secret to meet with the lawyers, to meet with the two parties that were talking about their confidential settlement. One of the lawyers happened to be on Foursquare. Everyone know what Foursquare is? Well, Foursquare is a way in which you can check in to a particular place, so your other friends who are on Foursquare can see where you are. It uses your GPS locator tracking on your smartphone. So they checked in to this restaurant in New York, and so they disclosed their location and whereabouts, and then they made a little post on this Facebook page about had a great lunch here in New York on a potential big deal. Well, they didn't disclose the client or whatever, but people would be able to put it together, and sure enough, someone in the blogosphere did a story about, these lawyers from out of town are meeting with these lawyers in New York at a restaurant, talking about a big deal, and speculating about this big deal. So I'm sure it didn't even cross the lawyers' minds that they might be disclosing confidential information through their use of Foursquare. Inadvertent formation of attorney-client relationship. Again, this is a problem where you participate in a chat room, and you know, there's now a website called Ask a Lawyer. Are you familiar with that? Ask a Lawyer. So it's Ask a Lawyer, and a prospective client writes in and says, you know, whatever their legal issue is. I just got divorced. I live in California. I want to take my child to Washington for a move. We're still in a divorce in the final. Can I do that, or whatever? And so all the Washington lawyers who are in the domestic arena start writing back and saying, well, you know, I'm not giving legal advice, but you know, here's this, blah, blah, blah. Well, maybe they inadvertently formed an attorney-client relationship. So it's just something, again, you need to kind of think about. Contact with clients and prospective clients. We don't have time to talk about that yet, but you all know there are rules against solicitation and things of which you can and cannot do. Well, those rules are equally applicable to social media. The ABA, under their 2012 initiative, is looking at the issue of should the rules of professional conduct be totally rewritten in light of these new developments of new social media platforms. It looks like what they're going to end up with is saying no, but we need to, in the comments, we need to make it very clear that these rules do apply to social networks, and we probably need to educate lawyers about how they potentially could apply. So, what are the sort of the takeaways here, and then I'll open this up for questions. More and more clients are utilizing the social media platforms, not only in their personal lives, but in their business lives. Every single major company not only has a web page, they have a blog, they have a Twitter account, they have a Facebook page. It is just the established way of doing business. Those are your clients. They're using these new technologies. You need to be up to speed on. If you're not using them yourselves, you certainly need to understand them. The pool of potential evidence is just has grown exponentially because of social media. If nothing else, I don't know where my number 2 went, but if nothing else, number 3 ought to get you off your dime, because all your competitors are using social media to market themselves. There is a 12-person boutique personal injury lawyer firm in South Carolina that has a staff of 15 that all they do is manage their social network accounts. They have about 10 blogs. They have, you know, which needs content all the time. So it's just amazing how lawyers are beginning to use social media to market themselves and promote themselves. The big Wall Street firms, you know, they no longer send out client alerts or have little client seminars or whatever. They do videotapes of lawyers doing a CLE like I'm doing right now, and they post it on their dedicated YouTube channel of their law firm. They have weekly audio podcasts where a lawyer is talking about a particular topic. All their practice groups have blogs. It's just amazing how they're beginning to just scratch the surface on using social media as a marketing tool. Ethical opinions or ethical principles do apply, but they're not always readily apparent, so you need to keep that in mind. And then the final takeaway is it's a new world. It's a new Web 2.0 world, and lawyers need to be diligent. Okay, question? Yes, Scott.
Yeah, are these Facebook pages and the like generally just open to discovery? The way it comes up in my situation at least is personal injury cases, defense wants everything that they've ever posted on Facebook to see if the person's really heard the bad, as they say, or if they've been out things like that.
Yeah, so the question, if you couldn't hear, is social media evidence generally discoverable? The short answer is yes, if you show that it's relevant. Basically the same, as we all know, the scope of discovery is broader than the scope of admissibility, and if you can show that it's arguably relevant to your case, yes. The overwhelming majority of case decisions say yes, it's discoverable. Now, some will say, will allow you to discover it for a certain period of time. The most recent decision I saw, which I thought was fairly creative, the plaintiff was seeking access to the defendant's, personal defendant's social Facebook account, and you know, the defendant objected, saying, look, I've got all sorts of things. Maybe there's something relevant. Yeah, I've made a few comments about this SOB who hit me, you know, but I've got all my communications with my family and personal things and whatever. So they shouldn't get access to that. So in that instance, the judge said, well, I'm going to order you to give them your password, and I'm going to put a protective order that says you can use this only for the purpose of this litigation. You may not disclose it, and it is a confidential, and only things that are admitted into evidence will become part of the public record. Don't file anything. If you do, file it under seal, and we'll give you 10 days, plaintiff's counsel, and then after that, the defendant may change their password on their Facebook account. But the general answer to your question, Scott, is yes, it's going to be discoverable if you can show that it's relevant. Hey, any other questions? Yes.
So you talked about communication with jurors, clients, and judges. As a damages expert, I'm interested to know if you've got thoughts on social media interaction between attorneys and damages experts of any sort, really.
Well, I think the usual rules, of course, we know the federal rules have recently changed, tightening up what is discoverable in terms of retaining attorney communications with an expert, and whether you can get drafts of experts' reports and things of that nature. So, you know, some states still allow discovery of all of that. So I think the short answer to your question is the communications channel or the means really are irrelevant. So it would be discoverable for your emails between you and your expert, or telephone recordings or whatever. If that would be discoverable, if you did it through a social media channel, that likewise would probably be discoverable as well. You probably ought not to be communicating with an expert. Certainly probably ought not to be communicating with your clients through a public social media forum, because that potentially waives the attorney-client privilege. So I think the analysis would still be the same regardless of the communications platform. Other questions? Okay, thanks very much.
I heard it's just a complete.
Yeah. See you later. See you. Give me babysitting tips, Kathy. You give me babysitting tips.
Babysitting grandchildren tips.
I should know.
Son-in-law.
Yes.
Oh.
They're my kids.
Sharon Donovan.
Oh, yes. Hello.
Tell me your name.
Ben Lear.
Ben Lear.
Yes.
You're with Bill Lear?
He's my uncle. Yeah, I just joined. I was at BandCon.
Oh, were you? Because I Jill helped me on a divorce case in London involved
Financial mineral
mineral
Sure.
rights and stuff.
Yeah.
Yeah. So it's nice to meet you now.
Nice to meet you.
There was a woman.
Carol.
Carol.
Yeah, it's
That's
my
your mom.
She's just at the state office. She's just a walk away.
Right,
State Office
okay.
of
She was at law
Education.
school with me, and we were pregnant with his older brother together, my older
So I was in your,
And me. Yeah.
I was in your class in law school. Was she in our
No,
class?
she was one, she was a year younger.
Okay, okay, but she was pregnant. Oh, wow. And so you were one.
That's right. So I went to law school twice. It was all reviewed at the time.
Years later, our son would get married.
Isn't that fun?
Yeah, for now.
Really?
Well, we had a lot of mutual friends, but she went to both played soccer going out, but she went to West, and so we had a lot of mutual friends who were.
You never know.
That's right.
What's going to happen?
And I know Ashley speaks so highly of you. I think she interviewed with you when she was in school.
Your daughter. I met with your daughter. So you're married to the daughter that I taught to that's the lawyer.
That's right.
Oh,
That's
yeah. I
right,
wanted to hire her, but in the meeting, then she needed to have a decision. I wasn't